There will be a second reading.
It had to be seconded. Yes, I'm sorry. Okay. Second reading.
Madam Speaker, I move that the Senior Counsel and Senior Attorney Bill be read a second time. Madam Speaker, I never thought I would be bringing such a bill before this House whilst I was Attorney General, whilst I am Attorney General. It was never my intention, nor part of my instructions when we were preparing the government's programme, to do so. There were other enactments which we were looking at and which we have, some of them have already been passed this year. However, here we are today with a proposed legislation to clarify and improve the process for the appointment of senior counsel and senior attorneys. One born out of necessity and forged in a spirit of dialogue. One which I hope will put to rest the utter confusion that has reigned recently on the subject. But first, Madam Speaker, allow me to address a vital question. How did we get to this? You see, the tradition of conferring titles upon lawyers did not begin in our part of the world. It began, as many of our legal habits did, like addressing the Chief Justice as my lady, in England. The title of King's Counsel or Queen's Counsel, depending on the sovereign, first appeared in the early 17th century. It was a recognition of seniority, skill, and service to the crown, and for centuries it remained one of the most visible markers of professional distinction at the English bar. Originally, the title was a personal mark of favour, of royal favour, granted directly by the monarch on the advice of the Lord Chancellor. It was not the judiciary that conferred it, but the executive acting through the sovereign's prerogative. After all, it was the King's or Queen's Counsel. Yet the courts themselves quickly gave it life. They recognized the precedence that came with the title and allowed those appointed His Majesty's Counsel learned in law to enjoy privileges that ordinary counsel did not. They were heard first in court. They sat within the inner bar as opposed to the outer bar, and they wore silk gowns, hence the term that survives to this day, taking silk. Those privileges, though symbolic, were not without consequence. They signified a degree of mastery of advocacy and of trust in the advocate's independence. Today in the United Kingdom, the system still bears the imprint of its royal origins, but it has been modernized to reflect democratic and merit-based principles. The appointment is now handled by an independent body. Applications are invited publicly. Candidates are assessed against clear criteria, including integrity, understanding of the law, excellence in advocacy, and contribution to the profession. Recommendations are made to the Lord Chancellor, who then advises the King. And we all know who the Lord Chancellor is and where does he sit in Parliament. You will have noted, of course, Madam Speaker, that the Lord Chancellor, being the Minister of Justice in the United Kingdom and a member of Cabinet, the role is that of an executive, of someone of the executive. The final step is the issue by the King of letters patent, but the process itself is essentially the result of the work of the independent panel, which includes lay members alongside judges and senior lawyers. The idea is to ensure that excellence at the bar is recognised by society at large, not merely by the profession itself. Now, across the Commonwealth, the model evolved in different ways. In some jurisdictions, especially those that have become republics, the title of King's or Queen's Counsel have been replaced by the title Senior Counsel. In Australia, for instance, Senior Counsel are appointed by the Chief Justices of each state, often upon the advice of a selection committee that consults widely amongst judges, peers, and the profession. The criteria are again merit-based, demonstrated ability in advocacy, integrity, and independence. In Canada, the evolution followed a somewhat different path. The title of Queen's or King's Counsel remained, but responsibility for appointments passed to provincial governments under statute. In most provinces, the Attorney General or Cabinet makes the appointment, sometimes following the advice of the Chief Justice or of an advisory committee composed of senior members of the bench and the bar. Eligibility criteria are often codified: a minimum number of years in practice, record of integrity, significant professional achievement, contribution to the administration of justice or to the community. Let us take the precise examples of British Columbia in Canada. The King's Counsel title is conferred under the King's Counsel Act by the Lieutenant Governor in Council, acting on the recommendation of the Attorney General. Before making any recommendation, the Attorney General must consult a small advisory group composed of the Chief Justice of British Columbia, the Chief Justice of the Supreme Court of British Columbia, and 2 lawyers nominated by the Law Society. In practice, this group is supported by a broader advisory committee. The Attorney General retains the final discretion to advise Cabinet. India's system for designating senior advocates, roughly analogous to our Senior Counsel, had long been criticized for arbitrariness and lack of transparency. In the case of Jai Singh in 2017, petitioners challenged the existing practice as a beauty contest because the process lacked objective criteria, public call, or reasoned rejections. As a result of that litigation, the court framed guidelines of 2018 for designating senior advocates. Under those guidelines, a permanent committee for designation of senior lawyers was to be constituted, comprising the Chief Justice of India as chair, 2 senior Supreme Court judges, the Attorney General, and a bar member nominated by the chair. Applications are evaluated via a secretariat that collects data on reputation, volume of work, nature of work, advocacy record, and professional standing. All this is then forwarded to the committee for its decision. Madam Speaker, I could go on and speak about Singapore, Hong Kong, South Africa, but it would belabor my point, which is there is a great variety of systems in place around the world in established democracies, and they all have chosen particular combinations of roles for the judiciary and or the executive and or their professional peers. Now, let us see what avails here today. In Mauritius in 1984, the Law Practitioners Act did not provide for the titles, as the British awards of QCs were still in place. Things changed with the advent of the Republic. In 1992, Counsel Emeritus and Solicitor Emeritus were introduced in Section 9A of the Law Practitioners Act, and their mode of designation was one we still use today. The said Section 9A was, by virtue of Act 6 of 1995, amended, and the appellations of Counsel Emeritus and Solicitor Emeritus were changed to Senior Counsel and Senior Attorneys in 1995. And in 2001, Section 9A was again amended to provide for a minimum of 15 years standing as sole eligibility criteria for appointment. Therefore, Madam Speaker, under the current law, the appointment of Senior Counsel and Senior Attorney is a shared process between the judiciary and the executive. Section 9A of the Law Practitioners Act provides that the President may, and I stress the word may, as opposed to shall, on the recommendation of the Chief Justice, appoint barristers and attorneys to these honorary titles. The word may is key. It means the President retains a discretion, but a discretion limited to the recommendation, nothing more. There is no power to add to the recommendations. And under Section 64(1) of the Constitution, the President exercised that discretion in accordance with the advice of Cabinet. In other words, the Chief Justice recommends, but the President, acting on Cabinet's advice if he so wishes, decides. It is therefore a collaborative process, not one belonging exclusively to either branch. The judiciary identifies merit, the executive ensures propriety, and acts through the head of state. Together, they give effect to a constitutional balance that respects both independence and accountability within the separation of powers. But truth be told, its application has never been easy or straightforward. I'll concede that. In June 2010, then Chief Justice Young Sik Yuan broke a 15-year silence in the appointment of Senior Counsel. Only 2 had been named since 1995, and this was in 2003, creating what he called a barren period. His decision to recommend 16 new appointees as Senior Counsel at once was, in his own words, and I quote, an act of corrective justice, meant to restore balance after years of stagnation, to replenish the ranks of seniors at a bar that had grown in size, and to ensure that the profession could transmit its best traditions to younger lawyers. The then Chief Justice therefore introduced a method that was his own, but it had its merits. He said that he undertook written consultations with all judges, all QCs, and all senior counsel. And he relied on guidelines which had been drawn up after discussions with the Bar Council and the Law Society. Chief Justice Sik Yuan wanted these guidelines published on the Supreme Court website for the sake of added transparency. This practice, it would appear, Madam Speaker, has not been followed since. In fact, Madam Speaker, there have been many difficulties over the years in the appointment process. In the last 32 years, this exercise has been carried out on very few occasions. 1993, 1995, 2003, 2010, 2016, and in August of this year. I have been informed that the 2016 nominations were the subject of a back and forth between the President and the Chief Justice of the time, leading some to questions whether the process had been followed by all. I also know for a fact, Madam Speaker, that under the previous government, recommendations of the then Chief Justice were not acted by the President at all, a decision which he was entitled to take, but which left, of course, a bitter taste for many in the legal and judicial sphere. Madam Speaker, over the years, the recommendation process became seen as a burden for the different heads of our judiciary. None were willing to single-handedly pick names and then potentially engage in a tug-of-war with the executive without mentioning the criticism from those that were not picked. The situation became such that upon stepping in as Attorney General in November 2024, I immediately started discussions with the Honourable Chief Justice on this issue. I put forward the fact that no new appointments had been carried out since 9 years, and I pledged to support any efforts you would undertake to remedy this. Madam Speaker, unfortunately, once again the appointment process for senior counsel and senior attorneys has reached an impasse. A few months ago, recommendations were submitted to the President in a list of 33 names of counsel and attorneys for appointment. Acting under Section 9A of the Law Practitioners Act, the President appointed 31. He did not add any new names. The President simply declined to act on 2 recommendations. And I can say, Madam Speaker, that the President was, in law and conscience, perfectly entitled to act as he did. What followed, however, was gridlock. No ceremony to hand over the letters patent, apprehensions on whether the process was valid, a judicial review based on these apprehensions, all paralyzing what ought and should be a very simple process of collaboration between 2 branches of power in Mauritius. But mistrust, speculation based on misinterpretation of the existing law cannot be allowed to endure, Madam Speaker. This bill before Parliament, therefore, seeks to restore clarity, transparency, and institutional balance. This bill remedies the shortcomings of the existing Section 9A of the Law Practitioners Act by replacing a system centred on a single office holder with a structured collective process. Its central innovation is the creation of a recommendation panel, as we have seen avails in most Commonwealth countries, which will replace the Chief Justice acting alone as the body responsible for proposing name to the President of the Republic. Madam Speaker, under Clause 4.3 of this bill, the panel will consist of the Chief Justice's chairperson, the senior Puisne Judge, and the next 2 senior-most judges, therefore the numbers 1, 2, 3, and 4 of the Supreme Court. The Attorney General, the chairperson of the bar, and the President of the Mauritius Law Society Council. And where any of the 2 professional representatives is not a senior counsel or a senior attorney, their counsel must designate one who is. This ensures that the voices of both branches of the professions are represented. There is a provision for a quorum of 5 members on the panel and a possibility for designated replacement should conflicts of interest make a quorum impossible. This is therefore a clear mechanism to avoid the stagnation of the past. The eligibility threshold for our appointments, 15 years, remains unchanged. Madam Speaker, under Clause 3.1, a nominee must have been a barrister of an attorney for at least 15 years, and his name must not have been erased from the roll of law practitioners. Clause 3.2 makes it explicit that non-practicing barristers may be appointed, recognizing that some who have served their country in public office or other capacities continue to embody the distinction and contribution that the title seeks to honor. The bill also makes it clear that the title of senior counsel or senior attorney is honorary and creates no legal right or entitlement. The bill introduces for the first time a regular timetable for appointments. Under Clause 6.1, Madam Speaker, the panel will meet as and when required, but it shall, in any case, every 3 years make recommendations, if any, to the President. There might not be anyone to recommend, but they must at least meet and decide that there are no one who can be recommended. In its deliberations, the panel will be guided by broad, merit-based criteria as set out in Clause 6.2. The criteria, Madam Speaker, include contribution to the development of the law, special skill or expertise in the legal field, academic or professional distinction, good standing in the legal fraternity, and personal qualities of competence, integrity, and fairness. Clause 7 provides for a ceremony at the Supreme Court to confer the letters patent issued by the President to the new appointees. No more gridlock. The remaining provisions regulate the use of the honorary title and provide for its cancellation where a practitioner is struck off the roll or otherwise ceases to be qualified as a law practitioner under the Act. In essence, Madam Speaker, the bill widens the base of recommendation, diversifies participation, replaces opacity with procedure, and it introduces a framework that blends judicial leadership with professional representation and constitutional oversight. Madam Speaker, having elaborated on the why this bill was needed and what it contains, I will now, with your leave, address two important subjects of ongoing debate, or should I say ongoing confusion on the subject. First, Madam Speaker, is the idea that we are somewhat depriving the Chief Justice of inherent prerogative of her office. I stress inherent prerogative. An inherent prerogative, Madam Speaker, is one which, even if not defined in statute, must necessarily exist for an institution to fulfill its role. For instance, the Supreme Court decision in Gimel in 1993 recognized that admitting or removing a barrister from the role is an inherent disciplinary function of the judiciary. That is, a power essential to maintaining the integrity of the court and therefore part of its core judicial authority. That arises because the courts must be able to control who appears before it as an aspect of administering justice. The designation of Senior Counsel, however, Madam Speaker, is of an entirely different nature. It does not determine whether a person may practice, nor does it discipline or regulate advocates. It is an honorific recognition of standing and contribution created purely by statute under Section 9A of the Law Practitioners Act. It confers no special right of audience and does not affect the exercise of judicial power. Crucially, as we have seen, the law provides that such appointments are made by the President after receiving the recommendation of the Chief Justice. By contrast, the admission or removal of counsel from the role of barristers lies exclusively within the court's jurisdiction. The executive has no part to play in it. This clear difference confirms that the appointment of senior counsel is administrative and collaborative, not an inherent judicial prerogative like the admission on the roll, and the two issues must not be hastily conflated. Indeed, Madam Speaker, the designation of senior counsel or senior attorneys is not a judicial function because it does not involve any exercise of judgment over legal rights, the interpretation of the law, or the resolution of disputes, which are they not, the essential elements of judicial power. Thus, nothing in the Constitution or in the inherent powers of courts creates or implies such a function. Its source is therefore purely statutory at Section 9A of the Law Practitioners Act. In other words, the judiciary's role here exists only and only because the law expressly provides it. There are no inherent powers in the judiciary for that function, which is not a judicial function. Secondly, Madam Speaker, some have sought to rely on the Indian case of Jai Singh in 2017, which I mentioned earlier, one of the very rare authorities on the issue, to argue that the power to designate senior advocate is inherently and exclusively vested in the courts. Very far from the truth, I'm afraid, Madam Speaker. Such a view is, in my humble view, most incorrect. The actual issue in Jai Singh was how the courts should exercise their statutory powers, not who, executive or judiciary, possessed the powers. That was the ratio decidendi of that case. Jai Singh confirmed that the power to designate senior advocate comes from statute, the Advocates Act, just like we have the Law Practitioners Act in Mauritius. The court treated it as a statutory function, not a judicial function, one that must be exercised with fairness, transparency, and clear criteria, and issued guidelines to ensure that standard. And when the Jaising judgment says that the power, and I quote, is always vested in the judiciary, it was merely and only saying that the Indian statute already says so, and that there was no need for the new guidelines to re-establish it. In fact, Madam Speaker, to say otherwise, that is to argue that such a process is necessarily part of the exclusive functions of the judiciary, would be to imply that somehow any other country, any state, where the judiciary does not hold complete control of the process, is encroaching on the prerogatives of its judiciary. So from Canada to England, dangerous breaches of the democratic principles would thus be taking place and be accepted by the courts. Does it make sense, Madam Speaker? The answer is a resounding no. Madam Speaker, clear rules, balanced participation, avoidance of gridlocks. This bill restores order in a climate of confusion and distrust. Each branch will have its role. The judiciary will lean on assessing merit, assisted by the bar. The President will continue to act as guardian of the Constitution. That is the choice of balance which we have made. The bill is not about power, Madam Speaker. It is about putting things right. We are not here to defend habits, but principles. The rule of law is not weakened by clarity. It is strengthened by it. Mauritius deserves institutions that work together, and this bill helps them do just that. I therefore commend this bill to the House.
Seconded.